Thanks for joining. And yeah, before I get going, I hope you're all well. If I can just also say thanks so much for all of the instructions that we get. We really appreciate it. If you need help, please give us a shout, give me a call, drop me a WhatsApp or an email. Happy to get involved and help you with your matters. So yeah, thank you very much. I'm going to cover today a couple of topics, and really the theme of my topics are the sale of freehold and movable property, although it covers sectional title as well to a large degree. And I really wanted to cover these, and the reason why I don't know, use the word crammed, why I crammed all these topics into one, because I think that they just fit together all so nicely together. And the overriding theme of I think my entire talk has got to be that we as estate agents and property professionals, when we sell property, we have to approach the product that we're selling with the eyes of a property professional. We need to try and be as comprehensive as we can without killing the deal, but we need to be as comprehensive as we can and understand the parameters of what we need to do in order to sell this property. Because what I find is we enter into agreements. After the agreement, there's problems and there's arguments and there's allegations of non-disclosure, and I think that a lot of these things can be avoided. And again, I know we're going to be talking in an environment now where it's very clinical, it's very easy. We're not dealing with those difficult personalities, so I completely understand it's not as easy as it may seem. But I always believe we must start off from the approach where we're going to get to the ideal first. So let's start with building plans. So building plans, the first myth I want to tell you about is that, and I had a client tell me this yesterday, that the first myth is that people say to me it's unlawful or illegal for us to transfer a property without approved building plans. The reality is there's no legal requirement on us as conveyancers, the deeds officers, you as agents, to ensure that there are up-to-date approved building plans in place, and that includes banks. All right, so if the deeds office wanted it to be a requirement to transfer a property, well, they would make it, or they would make me lodge some kind of confirmation that there are approved plans in the deeds office. But that's not the requirement. I can lodge and transfer a property without approved plans. It's not an obligation on me unless it's given to the offer to purchase. The second myth is that people are of the view that the city council must have my plans, and it's the city council's job to have my plans. Therefore, I shouldn't worry about it because they got my plans. That the reality is the city council doesn't view it as their job at all to have your plans. And if you find plans at the city council, well, you're just damn lucky that you did find those plans. So, as I've got you, I thank your lucky stars that you did find them. But I mean, can you imagine if the city council had a legal obligation to retain plans? They would be sued every single day by somebody for losing their plans. So that's simply not the case. The legal position, there was a case that was decided in 2007. If I just demonstrate the point, it was Van Nieuwenkerk versus McRae, and what the court said in this case, and this is the previous law, not the existing law, right? And what the court said here was that in the sale of residential property, the buyer is entitled to assume that the property and the improvements are erected in accordance with statutory requirements, and this is deemed to be, and the assumption is implied. It's implied in any agreement, okay? So that's it's implied, or at least tacit term, that what you're selling me has approved building plans. And of course, this was in turn overruled in the current law, which is the case of Odendaal versus Ferraris. And this is the case which sets out the legal precedent. And I'll give you some detail in this case, which I'd like to go through, because it just sets out how the law is operating in these cases. All right, so, and this is, by the way, also a precedent case in regard to disclosure and defect. So essentially what happens in this case, the defendant buys the property from the plaintiff, the defendant moves into the property before occupation, and he alleges that there's various latent defects in the property, in the carport, and an outbuilding, and he also alleges that there's no building plans for the property. They're lodged in the deeds office. The defendant, who's the buyer, tells his bond attorneys, do not register the matter because I'm not happy because I don't have my building plans and there's problems. And by the way, one of the issues here, interestingly enough, was that there was a garage, and when they viewed the property, it was locked, so they couldn't get into the garage. When they moved into the property, they moved in and sort of full of damp. And let me come back to that in a moment. So the buyer says the bonneteers don't register. The seller says, you know what, you're in breach, and he places the buyer on so he essentially, he doesn't place him in breach. He sends him a letter and he says, you're repudiating the contract, and therefore I'm entitled to cancel that contract based on that breach. So the seller cancelled the contract because the buyer refuses to register. The seller then applies to court for the eviction of the buyer from the property, and the buyer opposes the eviction on the basis that the seller wasn't entitled to cancel the agreement. Okay, the seller alleges that the footstewards clause protected him against the allegation of latent defects and the allegations of the absence of statutory plans. Right. So what does the court what does the court decide? Okay, I'll jump to slide. Got it. Okay. So what the court says is a number of things. Okay. In the absence of statutory approvals, the absence of statutory approvals don't render the property unfit for the purpose for which it was sold. All right. The absence the absence of approved building plans constitutes a latent defect. Okay. And to the extent that the buyer wishes to avoid the consequences of the footstewards clause, he must show that the seller was aware of the latent defect, he didn't disclose it, but that also that he deliberately concealed it with the intention to defraud the buyer. Okay, and in this case, the buyer could not show all those things. So the court held that the buyer had no basis to instruct his bonneteers not to register, and therefore he was in breach, and the seller was entitled to cancel the agreement. And the seller was was granted the eviction order. Okay, now, so I'm jumping slides again. So what's important about this case is the court decides very definitively that the absence of building plans is regarded as a latent defect. Okay, now let's look at this for example. I sell a property to you, and I am aware that there are no building plans. I am aware of the latent defect. I must disclose the latent defect to you. Second example, I'm selling you a property I bought from Mark. Mark did the alterations. I lived in the property. I never looked at the plans. I never considered it. I sell the property to you. I'm not aware of the latent defect that therefore I can't disclose it to you. Therefore, I'm protected by the footstewards clause. Okay, so you get the idea as to how this operates. What was also interesting about this case, and just as this is not part of the slides, but it comes in later, what the court decided in regard to the buyer's complaint about the garage, the court said, listen, buyer beware, you must inspect the property. If you buy a property and you didn't get into the garage when you bought the property, tough. That's it. If it's a disaster in the garage, buyer beware. You should have inspected the property. It's a patent defect. You did not, and therefore you must suffer the consequences. So that's what the court decided. Okay, and that's interesting for us to discuss a little bit later. So facts to consider arising from the case and around building plans. And this is just what I see, guys, is that I missed the slide. So there's various building plan considerations, all right? And there's various approaches taken by different agencies. You know, some agencies put a warranty in their agreement that there are definitely approved plans in place. Others use a disclosure document where there's kind of yes, no, unsure approach. I don't think that always works, by the way. Others, they completely avoid the issue. I have some agents who amend their disclosure document to take out the question because they don't want to be asked the question. So to ask or not to ask is the question. In our opinion, it's better to determine the issue. It's better to determine the issue and actually find out what are these building plans. Because, you know, guys, I've seen agents sell multiple properties and get blamed because they didn't get the building plans for the prior sale. They were the same agent. And, you know, people always come and blame you on this issue. And people are so aware of building plans. So, you know, be cautious. I'm not saying create a problem where there is no problem. Okay. But where a seller is aware is unaware that there's no building plans, needs to have some kind of written disclosure. If the seller did the alterations, he must be aware. So just understand that there are different approaches from different estate agencies. So let's just think about this a little bit. If you have an agreement in your clause in your agreement where the seller says we warrant that there are building plans. Let me tell you for a fact that the sellers do not take that warranty or the disclosure document seriously enough. They don't think about this closely. They honestly don't think about it closely like they should be thinking about it. And I've seen over the last year a number of occasions where there was a warranty and agreement that said, like a handwritten warranty. The seller warrants that he has building plans to the property. And you know what the sellers do? They make a whole bunch of assumptions. They don't check, they just make assumptions. So they make the assumption that because they bought the property from somebody else and that person said there were plans, there must be plans. Those plans are on the drawer. And then let me tell you, so 9 times out of 10, those plans are unapproved in the drawer. Then they make the assumption that they got the plans. They don't have the plans. Then they make the assumption that the architect that they paid to get the plans approved probably got them approved. He didn't get them approved. Okay, they assume that the council's got them. It's the council's job, so of course the council must have them. I'm saying that when you have a clause in your agreement, or when your seller gives you a warranty, it's actually not enough for us to just accept it. We must actually explain, tell the seller, listen, I've been down this road. I know what happens. Please have a look. Go and actually look at those plans. Take it very, very seriously, right? Protect the sellers from themselves and from their assumptions. Best practice, in my opinion, get the plans. When you've got a serious buyer, give it to the buyer, let them go through it, and then record in your agreement, okay, that and this is the last paragraph here, the purchaser records having been given copy of the approved plans for the improvement of the property and is satisfied with those plans. That's a fairly simple way to do it. Guys, banks and plans. We make the assumption that the banks are going to always want plans. Let me tell you something. They don't. They don't. We actually found that it's unusual for banks to ask for the plans. If they do ask for plans, it's because they've been to that property and the property looks like it's been altered and there's alterations, and the bank as a precaution asks for the plans. Failing the bank making the condition of the bond, it's not part of the bond process, and we simply move ahead without regard to that at all. Okay? Sale agreement clauses. If your buyer says, I absolutely want plans and I want them before registration, well, this is the clause that you can use. The seller undertakes the seller's costs prior to registration, provide approved building plans, which plans correctly reflect all improvements to the property and are approved by the city council. Registration transfer will be delayed until the sellers comply with this obligation. And you guys, can you see how specific the clause is? And the reason why it's so specific is the last seller that I spoke to, the clause said the seller undertakes to provide approved plans before registration. The seller brought me plans that were approved, but they didn't contain all the improvements to the property. So there was like an outhouse and a garage not on the property. He said to me, well, here's my approved plans. The clause just says approved plans. It doesn't say all the improvements must be on the property. It just says approved plans. So I said to him, listen, as soon as you got those approved plans and you build something else, your existing plans become invalid. So you've got to give me approved plans with all improvements. And of course, he was just trying his luck, and that's what sellers do. Okay, plans after registration. Guys, this is a tough one because I hate doing plans after registration. Sometimes we have to, but here's a clause that sometimes does work. So we say the seller undertakes the seller's cost to provide building plans, which must be approved and must have all improvements. Same as the previous clause. In the event that the plans are not approved prior to registration, the parties agree registration transfer will be effected by conveyances, notwithstanding that the plans are not approved, subject to the following. 1, the seller shall provide written confirmation that the architect appointed has been paid in full. 2, the appointed architect shall provide written confirmation that in the architect's professional opinion there are no impediments to the successful registration of the plans post-registration. This is really important. I want the architect to go there and to look at the property and to give me a letter to say that this is possible. Why? Because I'm not an architect. I'm not a professional architect. I have no idea, and nor do you. And here's the reality. The sellers go overseas, they immigrate, they go insolvent, and they die. That's what happens. And then what happens is, we as the conveyancers and you or the agents are left carrying the can. The buyer looks at it and says, but where's my plans? Why can't I do this? And I'm going to raise another issue with you in this next slide. And of course, the next point here, the conveyancers will retain the sum of 5,000 Rand after registration of transfer in trust until successful presentation of the plans. Now, guys, some buyers want 500,000 Rand or 250,000 Rand, and others are kind of happy with 20 or 30,000 Rand. For me, the bigger the amount, the better, because I'm wanting protection here as well. All right. Okay. So next slide. There's just some considerations arising from above. If the banks don't make it a condition, it's not a bond. It's not a bond condition. Plans after registration, there's various risks. As I've discussed, get the architect to give you a letter to say he has assessed and he's going to do it. Guys, with all respect to architects, the ones we deal with, I found them to be relatively unreliable, unfortunately. Best practice. Yeah.
Sorry to interrupt you. There's just a question, and it actually deals with your first point there, is that some of the banks are demanding the plans. So the question is, how does one deal with that? So in the instance where the bank has actually made it a condition.
There are cases where the banks do ask for plans. And if the banks ask for plans, and it's actually a very good point, and I'm glad you raised it, I must add it to these notes. If the bank does ask for plans, and there are plans, no problem, we hand those plans in. If there aren't plans, in my opinion, it's an unusual term and condition of the bond, and potentially it doesn't even fulfill the suspension condition. And the question then arises, are we going to get the plan? So let's, for example, I'm the seller, you the buyer, you get a bond, the bond condition says, well, we got plans. And I say, I don't have plans. I don't have plans. Now we must enter into an addendum where I agree to give you plans as an example. And then transfer is delayed until such time as we get the plans approved. So if we agree, transfer is delayed until such time as the plans are approved. And the bank our experience is the banks are not going to compromise on this. And architects will tell you that they'll register plans in 3 months. It's not going to happen. It's going to take 4 to 6 months at least. Sometimes longer, especially with COVID now. They're closing every other day, so it becomes an issue. And let me give you an example. We had a transaction here in the office where the bank did raise a condition, and when we got the architect in, that very last point, I said, be cautious of town planning issues such as zoning. What happened was it was a property in Blegari, and the sellers had converted their garage into an additional dwelling. The town planning scheme didn't allow for a second dwelling. We had to rezone the property for special consent use to allow for the second dwelling. Once that was done, we had to then present the plans to the city council for approval. Also, the reason why it's important to get an architect involved is sometimes in schemes like cluster schemes, the cluster scheme is granted as a town planning issue with a certain amount of bulk, and the bulk only allows for a certain amount of coverage of the property. So I have an example now of a cluster property in Lone Hill where the architects are telling me there isn't enough bulk to extend this property. So the seller built without plans, but they're actually not allowed to. Now we've got a problem where we must apply to the council to allow more bulk. Now, try and get people to understand this bulk issue is an absolute nightmare. But I'm saying, take it out of your hands. Get the architect to certify that it is possible to register plans post-registration. Or if you want to, if it's a bond condition, get the architect to certify, yeah, it's possible. This is how long it's going to take. Okay, so those are. I mean, I had a case with building line restrictions. The neighbor hated the seller and wouldn't sign off the building line restriction. We can get around it, but it takes time and it's not as easy as we'd like it to be. So those are just some of the issues that we need to consider with building plans. It is a relatively complicated issue. Okay, frag. Let me deal with it quickly. Any property that is older than 60 years of age is subject to frag. You can't make any alterations, any changes, anything to this property without first applying to a government organization called FRAG. It's the Provincial Heritage Resources Authority of Gauteng. Okay, so guys, if you are, and lots of properties now older than 60 years old, if you want to do alterations to a property that is more than 60 years old, you must apply to FRAG. It's going to take you probably 4 to 5 months to get approval, because that's just how long it takes. It's an independent body. The architects sit once a week to make the decisions. Okay, if you know there's FRAG, stick it in your offer to purchase. Okay, let's talk about disclosures. And I'm not going to go through this in any detail at all, because I've covered this, I think, in the last week or 1 month or two with you guys. And that is, you guys have your own disclosure obligations. So you guys must disclose, and this is your disclosure obligation, not the seller's. You must disclose facts which are within your knowledge, okay? Facts which ought to be within your knowledge, facts which are material to buyers or which may be material to buyers. So you can see it's a very, very broad obligation here that you need to consider, all right? So just kind of consider this as you go along. But this is for me is important when it comes to disclosures. All right. The disclosure document. With the advent of the Consumer Protection Act a whole bunch of years ago, various forms of disclosure documents were created. At the moment, please understand there's no current law that requires you to have a disclosure document. None. But it is a good practice if you're going to do it properly. Okay. I'm going to give you a slide up ahead, and I'm going to tell you about it now. The Property Practitioners Act, once it becomes enforced, has a requirement that's going to require you as an agent to, when you list a property to rent or you list a property for sale, to get a disclosure document. It's going to be compulsory to have the disclosure document. So disclosure documents are going to be part of our landscape. The disclosure document serves a number of purposes. One, it records the condition of the property for the purchaser. Okay, please, guys, these clauses that say, I get an agreement, it's signed, and the document says, disclosure document to follow in 5 days. How can that be? It's the cart before the horse. The disclosure document must precede the offer to purchase. The buyer enters into the agreement on the strength of the disclosures made by the seller to the purchaser in the disclosure document. You can't have an agreement, because what happens if I buy a property with a disclosure document to follow, and the seller discloses a whole bunch of things I wasn't aware of? Okay, do I have the right to get out the agreement? What are my rights? And that's why the disclosure document must be given to the buyer first before the offer to purchase, or preferably annexed to the agreement as an annexure. Okay, that's the way it should do. The next thing the disclosure document does, it serves as a record of the seller's instructions to you as the estate agent. Okay, it prevents the seller from disclosing at a later stage that there was a defect that they told you about, that we don't know if they did or didn't tell you about, and now there's an argument. But guys, I want you to also understand that the use of a disclosure document is a double-edged sword. It's absolutely a double-edged sword, because sellers who don't complete a disclosure document properly, it becomes a disaster. If you're going to do it properly. If you're not going to do it, don't do it at all. Okay, so disclose properly. Go from room to room, find the issues, and this is what I said to you in the beginning. Remember the theme. Approach the property with the eyes of a property professional, and assist your sellers in the process of disclosing. There's a tendency on sellers to think, well, if I disclose something, my property won't be bought. But the opposite is true. If you disclose, people will still buy your property, but you won't be called a liar after the fact. Obviously, if it's a massive issue, take care of it and deal with it. Remember that your reputation is going to be tarnished to the extent that there's a disclosure issue afterwards. People tend to blame you guys as agents. Where disclosure is not possible, something that the Estate Agency Affairs Board and the Property Practitioner legislation haven't dealt with as yet, is that, and I don't know how they're going to deal with it. I'm an executive in a state. I live overseas. I've never been to the property. How do I make disclosure? Well, I think there's a clause that you can insert into the agreement that gives you a little bit of certainty here. So here's my clause. We say the party record the prior to the sale, they're not being occupation of the property, or is an executor, and therefore is not able to make any disclosures, whether patent or latent. Okay, the purchaser records that they understand this, they bind the property in the condition which has been offered, and they also record that they've had the right to inspect the property. So what we're saying is, Mr. Buyer, the seller didn't live in the property. Mr. Buyer, the seller is an executor. He doesn't know anything about the property. So you as a buyer must go extra. You must go the extra mile to make your disclosures. Okay. How do we deal with defects, guys? I think that what we need to do is depends on the defect. You can either disclose it very clearly, or you must fix it. If you're going to fix it, don't fix it with a bucky builder, right? Don't fix it with a bucky builder. Get a reputable guy in. Guys, please be very cautious. This idea of getting warranty. So the seller will say, I repaired the leak in the roof. I repaired the damp over there, and I have a warranty. And then you go and write in your agreement, seller has a warranty to give to the buyer. Here's the thing, guys. Those warranties are not always transferable. I enter into a contract with the contractor. It's a personal contract. The warranty is mine and mine alone. I can't transfer it. So when I give it to the buyer and the buyer goes to the contract, he's going to say, who are you? Who are you? I didn't contract with you. I'm not fixing. So if you're going to have a warranty, make sure that it's specifically transferable to the next buyer, okay? And just be very careful, guys. Record things in your agreement or your disclosure document. Make sure it's properly done, because there are no variation and no variation clauses, no warranty type clauses, which end up creating problems for us, okay? The Property Practitioners Act, guys, are covered. It's coming. Be prepared for it. It applies to rentals and to sales, and there's various consequences for not complying. All right, guys. One of my last topics: fixtures and fittings. I'm going to tell you about a case which demonstrates how fixtures and fittings work. Right. So this is an old case, 1983, not a Supreme Court of Appeals or constitutional law court case. Just a case, and it's so nice to demonstrate the point, because we always traditionally are taught, take the house, turn it upside down, shake it, whatever falls out is a fixture and fitting. That's not true. So in this case, a seller sells to buyer. There's a dispute about two things: steel cabinets and bar stools, which the seller removes. Unbelievably, they go to court on the issue because the buyer wants these things returned, and the seller says, well, they are fixtures and fittings, guys. You can't, so they're not a fixture and fitting. I'm taking them with, right? So the guys go to court, and the court makes a decision. Sorry, I'm jumping around a little bit. So the issue to be decided is whether the steel cabinets and bar stools are fixtures and fittings, and if they did, well, then they form part of the property. What did the court decide? The court says that an accessory for the purpose of a contract must be regarded as part of the property and sold, and if it was destined to be a permanent service to the property, it was necessary for the effective use of the property. Where a fixture comprising more than one part is designed as a unit, then the principal part thereof is incorporated in the immovable property, then the loose parts of the unit also form part. Now this applies to the bar stools. The bar stools, same wood, same fabric. They were principal and component part, deemed to be of service to each other, part of the property. So what I'm suggesting to you guys is that when you sell a property, you must disclose and you must look at the fixtures and fittings. You must go around this property and you must find and don't create problems, find the issues. So look at the bar stools. I had more so 5 places, which is the guy had 12 in this property. He took them all out because they weren't affixed to anything. More so 5 places. Bathroom mirrors that are hanging mirrors. The Wendy hut. You know, these massive pot plants. Bar stools. The steel cabinets in this particular case, the court said were immovable. You can go down to your local hardware store and buy them. So what I'm saying, guys, is go through the property with the eyes of a property professional, all right, and avoid disputes. Look at things that can be, if you're selling high-end properties in Bedford View, for example, and there's sound systems and all these ancillary issues, I would clarify them all in the offer to purchase. I would create special conditions so I understand what it is that I'm selling, right? Because I think that what you want to do is you want to try and avoid disputes around these issues. Guys, please have a look at your fixtures and fittings clause. Some of you have a clause that says the seller sells the property with all fixtures and fittings which are in working order. Others say others only warrant that the seller sells the fixtures and fittings which are his exclusive property and fully paid for. Now, if you're going to say it's in working order, well, then all the fixtures and fittings must be in working order. So you must go around this property and you must look, are the fixtures and fittings in working order? Air cons, etc., etc., etc. Okay, so not to belabor the point because I'm coming to the end of the presentation, you know, the idea really is, guys, that, you know, you got to go through the property, make sure, and what I would do is I would walk around the external of the property. Is there a Wendy hut? Are there pay swings? You know, is the Wendy hut staying? Are there external fountains? You know, a lot of those fountains you pick up and you move away. Guys, this is what creates the real upset in people. So record Wendy house to stay. And some of you got this in your agreement already. Fountain to stay, fountain to be removed. Go into the house itself. Look around. Look at these issues. Hanging mirrors in bathroom will stay with property. So bar stools stay with property. Take an example of your curtains with those decorative pelmets, right? I can take the curtains off, but the pelmet is part of the property, but they're the same fabric. Do the curtains stay or do they go? And I promise you, we can debate these things endlessly. I'm just saying, check it out. My last point, okay, because I'm out of time. Home inspectors. So guys, home inspectors I know some people hate home inspectors. I know some people love home inspectors. They can work. What I'm suggesting to you is this. if you're going to use a home inspector, be clear, by when must the inspection take place? What is the consequence if the buyer doesn't do the inspection? Because what I found is buyers think it's a wonderful idea until they must pay the inspector R7,500. What happens if the defects are found? Does the sale lapse? Does the seller have an obligation to correct defects? And also just put yourself in the mind space of a seller. And I've seen many sellers who will refuse an offer where the buyer wants a home inspection. Why? Because once the home inspection is done, they get a 15 or 20-page report to tell them every single little thing that's wrong with that property. And as a seller, they don't want to know. They just don't want to know. So they don't want to sell to those people. So it's a double-edged sword. If you inspect, you're going to be pretty confident about your property. A clause that you can use is as follows, and this is my last slide. This is the clause I use. The purchasers may, at their own election, arrange for the property to be inspected. In the event that the purchaser identifying a material defect, and this is another important point, guys, you can limit the nature of the inspection. So you can say, okay, you can inspect, but only for major structural defects. Or you can inspect, but only for material defects. Okay, and you can argue, well, what does material mean, right? So if they identify material defects, the purchaser has the right to get out the agreement to sale at the election on written notice, unless the parties can reach some kind of agreement. Then what I do is I say the inspection must be attended to within 7 days, and then the written notice above must be given by the purchaser within 10 days of acceptance. So in other words, the buyer's got 7 days to expect and 3 days thereafter to say, I'm in, I'm out. Okay? And here's my last clause, and I always like this clause because it says, if the buyer doesn't do the inspection or he doesn't give the written notice in the 2 preceding clauses, then he waives his right. Then he doesn't want to inspect the property anymore. He waives his right in its entirety. And what I like about this clause is it gives certainty as to where we are. It gives certainty as to the process. Okay, guys. I'm 3 minutes over time. My apologies, Michelle. I went through that pretty quickly, but I hope that I've sort of covered.
Welcome to go over time. I think this was important.
I hope that I've covered the essence of it. And if I can leave you with one thought, guys, go to the properties with the eyes of a property professional. And again, I'm stressing this. Don't create a problem where there isn't, right? But if you see something that in your experience is going to be a problem down the line, do an addendum, put it in the offer to purchase, make those disclosures. It really does avoid a lot of problems going forward. All right, guys, I hope that was useful.
Yeah, I think